I reapplied for monetization with YouTube, right?
Okay.
And they just responded, and this is what they say. Thank you for your interest in AdSense. That's who runs the monetization for YouTube, is Google Adsense. After reviewing your application, our specialists have found that it does not meet our program criteria. Therefore, we are unable to accept you into our program. Here at AdSense, program policies are designed to ensure the effectiveness of our Google ads for our publishers as well as our advertisers. We review all publishers and we reserve the right to decline any application. If you are able to make changes to meet our program criteria, you may reapply for AdSense in the future. Please note that we may not be able to respond to inquiries regarding the specific reasons for our decision. Thank you for understanding. The Google AdSense team. Now, this goes into saying that, there are so many of these convict channels, these quote unquote convict channels, where these guys get out and they put bass in their voice and they talk tough, and they are all about this violence game, and they put out these episodes about inmates being raped in prison, and just every one of their episodes is just trash, essentially. It's just stigmatic trash. It's the same as these shows like Locked Up and all of these other shows that just, you don't know, anybody can get up and say anything that they want. You know what I mean? And it's all about just glorification of violence, for likes and subscribes. And these people are making a boatload of money off of YouTube. You know what I mean? They have 25, 30, 40, 50, 100,000 of subscribers. Larry Lawton has over 1 million something subscribers, and just to get up there and just say whatever. And as long as the people are entertained, they'll go along with it. But my channel, as you know, education and information, unity, love, positivity. I'm showing inmates that are coming home, building organizations and creating outreaches and becoming positive members of the community. And I am being censored heavily for it, heavily. So I just wanted to make that, because this is the thing. We're talking about the Constitution, and these are live events of what's going on against American citizens for just really essentially preaching love and unity.
Yeah, and we need to take into account, what is it that the media stations or the TV stations, what do they produce? They produce Law and Order. They produce, these movies that are all about a serial killer and going and finding them from the law enforcement, police officer, whatever, right? They're creating this image, this illusion, or this concept that crime exists, that there's this certain heroism within crime, within going out and catching the bad guy or whatever. So I think that it's all about. Well, it goes back to that saying that I said from Jim Morrison, where he said that life is not as romantic or as exciting as it should be. So we say things that are false because it's better that images be created. It doesn't matter if those images aren't true, so long as they're believed. And we're creating this, but we're creating this because we think that life needs to be more exciting. Why can't life just be caring and loving each other? Why is it that the news doesn't talk about the good things that happen every day? They only talk about the bad things. Because that's what sells, it goes back to like Rome, and the gladiators and everything else. History is simply repeating itself, and we're creating these gladiator events, these whatever, that we're taking the slaves and we're putting it into and watching them die and kill each other, and and finding humor in that, and the excitement in it, and then we're glorifying the ones that are creating the conflict. But conflict creates business. It creates business for a lot of companies, right? It creates money for a lot of different people. War is all about money. You get Lockheed Martin and And some of these big general prime contractors that make a fortune off of war. They want war. They want conflict. Same thing here in America. A lot of businesses are in the business of creating a response to conflict. National security, the whole program was based upon, this fear of terrorism. And, the terrorism is the people. It's anybody that goes against the government. And that's why national security was code word for domestic terrorism, because we were protecting the government from the people. And it's the wrong concept. But, that's what sells. But I think that if we got away from that and we started talking about the good, because that's one of the things that I like here is that it's important to, as a patriot, because a patriot is one who loves and defends his country. So patriotism is simply a dialogue between your fellow man and the larger world as a whole about not only what is good about your country, but what needs to be done better. We should be talking about the good that the country does. We should be telling everybody that we have a great country in theory, but not necessarily in practice. And we should love our country. And I think that when we're not teaching civics in school, when we're not allowing for people to come in and to be able to go through the legal naturalization process, they don't learn about what's good about America. They're coming in with this other belief. So every single country has its own spirit, right? The spirit of law.
Well, just to solidify that point, it's Arnold Schwarzenegger made it perfectly clear when he said, "The hell with your freedom, take the vaccine." And when you have immigrants that are saying that shows you that they don't understand the value behind what freedom really is.
Right. We have an immigration process, not so that you go through a process to become a citizen, not so that you sit in a program for years. And we do it so that you can learn to love America, because you have to understand America to love America. Right. And we should everybody here should love America, because this is our land. This was given to us. Our freedoms were given to us. That is the greatest treasure known to mankind, was what we had, what we were guaranteed, and that we've lost, and that we've forgotten. We've forgotten because we haven't come to continually learn to love our country and to maintain that love. So every country has its own spirit, right? It's the substance of that relationship, because society is just simply a relationship between a whole bunch of different people. But when those people come together, they have a spirit, and that spirit here in America is truth and justice. That was what we founded ourselves upon, and we all feel it deep down inside, right? And so we have these certain communal values that we have in place, these principles that we Americans, believe in and want to think are true, such as innocence doesn't suffer, and that you have a fair and reasonable process that's established and not arbitrary, and that the guilty are always punished, but the innocent are not. I mean, these are principles that we have in theory, but not in practice. And so we have to understand that when we have chaos, when we have an arbitrary change to our belief system, whatever we believe in, our spirit, that's when we feel that there's something wrong deep down inside. Something inside of us says that what they're doing is wrong. I can't quite put my finger on it, but I know it's wrong. That's simply the spirit of us, our spirit, telling us that they're doing something contrary to truth and justice, contrary to our principles and beliefs. And that relationship that exists, that relationship comes into turmoil and chaos when we have that occur across these different states. And so, we need to be a union. We need to be united. We need to treat everyone equally, because that will bring us back from this chaos that we're in today back into harmony, because constitutionalism advances naturally as a result of suffrage, right? But voting is the result of the majority, not of an individual. So when an individual or individuals such as the Supreme Court comes in and changes our principles and our belief set, then it causes us to feel like there's something wrong. It causes conflict, and then we feel that there's an issue and we can't quite understand what it is. So changes to our principles must be done by the majority, right? The societal relationship that we have in place, it must be done by majority so as to prevent this loss of harmony.
Before we get into self-incrimination, speaking on the votes real quick, how do you think that our vote really matters, right? And the reason why I asked that, I've asked this over time. And the reason why I asked this is because we just witnessed, Tana Wall, in California, over 2 million people sign a petition to oust that governor, and yet he still sits in that seat. They got the required signatures, yet this man still sits in that seat. That is a scary thing, because again, we are doing what we're supposed to do that was outlined for us to do in the event of a tyrannical government, and we did that. We got the petition. We signed the signatures to oust the governor of California, yet he is still in office. So does the vote even matter?
No, it doesn't. And it won't, because for one, the people aren't informed enough. We don't take the time to actually learn, what is right and what is wrong, or what people are doing and not doing. These promises are made by these politicians, and then they're never fulfilled. They make the promise over and over again. We talk about, I'm going to reform the justice system. When has it been reformed? Well, they make the promise, but they don't follow through.
The
right?
stats haven't showed no reform.
We have to hold them accountable. And the thing is like, Nancy Pelosi is a great example. How is it that she's amassed $196 million over the course of her career? That doesn't sound like a public servant to me.
You know what the liberals say? The liberals say is because she was rich going in. Her and her husband was in real estate. They were in stocks. They were already rich going in.
Okay. Well, the reality is when you make $193,000 a year and you're full time burdened with that job, do you really have time to be doing all this other stuff? I'm not using Nancy Pelosi as necessarily target. I'm simply saying
I'm with you.
These are wealthy individuals. These are multimillionaires. No one goes into the Senate and leaves there without having millions and millions of dollars, because you have these lobbyists that are coming at you. You completely lose touch with society because you're nothing but wined and dined by these organizations that want you to push their agenda, right? And so, Washington D.C. is a whole different animal. And once you get there, you lose touch with the rest of society, because it's a different relationship. You don't have contact with the normal common individual that's having the issues, but instead you have corporate lobbyists that are coming at you with money and entertainment and all these other things that tend to influence you in their thinking, to send you in their direction.
Don't you have more millionaires per capita in DC than anywhere else in America? Isn't that an accurate stat that I read somewhere? Per capita?
Yeah. When I lived there, if you didn't have $3 or $4 million, you weren't living within the district. It was millions of dollars for even a one bedroom bungalow. It was astronomical. And so, I was living almost all the way to West Virginia because that's the only place I could afford. It's extremely expensive. And
so moving. Go ahead.
There's a lot of advantages that exist within Congress and within, the lawmakers. So, one great example is that these are the guys that are creating the laws. So if there's a law that's going to impact, the sales of a product, then they sell their stock, right? Or if they're creating a law, or they're pushing a law through that's going to enhance a particular industry, they're going to invest in it. That's insider trading. Martha Stewart went to prison for it, and yet these politicians do it every single day, but they're immune. You can't touch them because they're above it, right? No. These guys are heavily, heavily invested in the very acts and legislation that they put into place every single day. That's where they're getting their money, And
at the end, they don't pay hardly any taxes, if any at all. You know what I mean? And like you say, all the perks and benefits that they get just throughout their daily life of being who they are. And then on top of that, we, the taxpayer, brunt the bill of everything that they do.
Yeah. Yeah. And then we don't hold them accountable for their inaction or their actions, and we allow them to maintain this argument of sovereignty, of this immunity, which is absolutely incorrect. And, the thing about it is, and I've mentioned this a few times, and I'll just go over it one more time here, right? But there is no immunity within the United States. You cannot have immunity. Sovereign immunity or sovereignty derives from the theory that the king can do no wrong, right? So it's the king that creates the laws, and as a result, he does it through the just practice. Therefore, you cannot charge a king with the crime. You can't sue a king without his consent, right? He has to give consent in order to do it because he's the one that creates the laws. So he can't violate the laws because he creates them. So here in America, we the people give the government the power to govern through the consent of the governed. We create the laws. Therefore, we are in fact the sovereign. We want our freedom. And with our freedom came our sovereignty. We each are individually the kings ourselves because we create the laws and we give them to the government and say, government, administer these laws because this is our agreement, this is our relationship that we've established among our people. And here we want you to do that, right? It doesn't, that makes them below us. We are above them. And so, that's like saying that the peasant is above the king to allow them to be sovereign, right? To allow them to be able to come in and do that. So when it says that the king can do no wrong, being the basis of sovereignty, here's the thing, right? Just like I said the last episode, the process of due process, the process of crime is you first bill, right? You bill for the crime through the indictment. Then you charge. Then you create and pay the bill. So it's a debt-based system. So you must bill first, then you charge, then you pay the debt. Okay. So in English common law, or in English, the nobles were known as nobility. Kings were known as nobility. And that's where that particular word derives from, is that a king cannot be charged with a crime because they have nobility. Right? You can't bill them for that crime because they have nobility. That's where that word comes from. So when you look at nobility, that is what you can't bill them for a crime because they are nobility. Okay, so the whole concept of sovereignty derives from the king can do no wrong, which is nobility. Okay, here in America, in the Constitution of the United States, Article 1, Section 9 says that the United States shall not create a hereditary of nobility. You cannot create nobility and patents of nobility here in America because everyone is exactly the same. No one is above another, right? You cannot say I'm not billable because I have nobility. We were not to have that. So the United States cannot create nobility. So those judges that say that they're sovereign and immune, they cannot be, because that is a title of nobility, saying I can't be billed for a crime. I can't be billed for this offense. Okay. Then in Article 1, Section 10, it says that no state shall create a title of nobility. So a state can't create it either. So these state judges that say I'm sovereign and immune, no, you're not. I'm sovereign and immune. You're my servant. You only exist because I, in my freedom, created your office. Therefore, I'm the sovereign and not you. Government is nothing more than an aggregation of the people, right? The states don't have sovereignty because the state is nothing but the people, right? Right. The people, the state is just simply the aggregate of the people. And if the people all have equal rights, the state can't have be above us, right? It can't. It doesn't work that way. We have a government that is to serve the people, and that service means that it is below us.
Which is why they the government won't allow Texas to succeed, right? Correct?
Right. Yeah.
As much as Texas wants to succeed and they file for it and all of these things, but they would actually have to fight the government, right? All 49 other states and able to succeed, right?
Right. And so that's the theory of federalism. So that was what they were thinking with militia and the insurrection. That if a state itself refuses to enforce the laws of the United States, what happens is they're no longer part of the United States. If you're not bound to the Constitution, you refuse to enforce the Constitution. Guess what? You're no longer in America. Like here in Washington, they don't abide by the Fifth Amendment. So this doesn't feel like America to me. I'm in some other country because everything that I have, all my beliefs and everything I believe in as far as America and the Constitution, they aren't real. They aren't true because here in Washington, they don't do the things that are required of them. So, in order to have harmony, in order to have a union, we have to have something that creates the unity. And that thing that creates unity among all the states is the Constitution, because there's nothing else. Our unity comes from faith in our laws. It's they and faith in them that unite us, and not the states. The only thing that unites Washington to Florida or California to New York is the Constitution of the United States and faith in it. That's what makes America America. So when you refuse to enforce or recognize the Constitution of the United States, you are no longer a part of America.
Well, this is how you got Washington with no grand jury. This is how you have New York arresting people for not having a vaccination card. And This is how you have Florida, where people are just walking around like nothing exists, like nothing's going on.
you can't, California, you can't go to church, you can't sing. I mean, for a year, they couldn't, if you sung, you were going to jail for a year. I mean, where's that coming from? It's coming from these states feeling as though they can act however they want. So they're coming up with their own individual sovereignty, in their sovereign status, the ability to be able to govern whatever way they see fit.
So
that is not a federal republic. That is a confederacy.
So
that is a democratic government.
Was Trump correct when Trump was saying, that he wanted the states to handle their own business as far as it came to COVID? This is what governors are in place for. Because my understanding is that, you have, the state has its own constitution. You have a state constitution that resides within the government constitution. And yet this state, that like the governor is the president of this state. So, I mean, is that correct?
No. So the thing is that every one of these governors work for the president. The presidents, they don't recognize that. They don't do it. But the executive officer of the state works for the executive officer of the nation, right? There were three issues that we were dealing with when we were moving from Confederacy to the Federal Republic. And I already went through the first one. That is the legislative branch. So we didn't have any way of making the states actually implement the laws that were created by the central government. So they created the legislative branch so that we have a representative government. They all make the laws and they are all in agreement because they have the legislative branch, right? And it's equally represented. So the next issue was that there was no executive officer in the federal side that ensured that the laws were being enforced within the states, being enforced and administered properly within the states. So they created the executive branch. The president is there to manage. Each one of the governors are subordinates to him. So when he creates a requirement, that should federate out to each one of the governors and to administer, to execute it. No, those governors work for the president, and so that president's in a position of uniting the people and uniting the states. That's his job, not to pull politics and badmouth half the nation. His job is to unite, is to be the representative for all the people and to speak for all the people, not half of them, but all of them. So, right. No, I disagree wholeheartedly that when we allow the states to do whatever they want, that creates a disharmony among the nation. Right? Mm-hmm. We don't want disharmony. We want a single, just like the judicial branch. If the Supreme Court makes a decision, that decision then flows out to every single one of the regional courts, and they have to follow it. Right? The same thing should happen with the executive branch. If he makes a ruling or an order, placed an executive order, then that order should go to all of the states, and they should administer it so that we have equal practice and application of the laws among all of governments. Otherwise, we have this disharmony. But you mentioned the state constitution. And the issue with the state constitution is that's the way the Confederacy works, right? If the states have their own laws, then that means that they're sovereign. And if they're sovereign, then remember when we were moving from the federal government or from the Confederacy to that, the third thing that we were dealing with was the judicial branch not having a high court that would be able to make a ruling that applied to a legal proceeding or a legal decision that would then federate out to each one of the courts. So the whole point in the three branches of government being separate and balanced is that each one of these three branches of government, they took away this localist view. So the Confederacy was all about the localist, right? So the states, they governed whatever the way they wanted to. There was a loose central government that associated from one state to another state, but there was no governing structure within that to be able to require the states, to each one to abide and to act in the same manner. So we had the confederacies that each one of these states said, we're sovereign, we can do whatever we want. We can govern our people however we want to govern them. And there was no way to require that. So when we became the Federal Republic and we adopted the Constitution, each one of these states gave up their sovereignty, gave up their ability to govern whatever they want, to become a part of the Union and thus be bound by the majority communal and societal relationship that was established through the Constitution of the United States. There were two different theories in what to do when we were dealing with the first Constitutional Congress. First was the localist view and simply an enhancement, and thereby maintaining sovereignty of the states and just increasing participation in the central government. Or we do something completely different and we fix these three issues that we have by creating three branches of government that are all separate but equal, and they're all sealed with their own individual duties and responsibilities. We have a major separation of separation of powers issue in everything that's happening today. So, you have the executive branch that's believing that they can suspend the Constitution at whim. They can make that decision because they're the president, and the president's that important. And then you have the executive, the judicial branch that's saying that they can alter, amend, and destroy the Constitution of the United States, such as in the case of Barron versus Baltimore, where they say that the Bill of Rights doesn't apply to as a restriction to the states, but only a restriction against the federal government. That is absolutely contrary to the Constitution. And when you have the judicial branch that says that the indictment by a grand jury is not required by the states, that is them altering, amending, or destroying the Constitution of the United States. That is not their job. That is the job of the legislative branch. So you have the separation of powers. You have the states themselves that are substituting their own alternative legislation for the provisions and guarantees of the Constitution. That means that the states are more powerful than the federal government. And if the federal government doesn't have the power to maintain its own unity, right? Because President Abraham Lincoln said, it has long been a great question whether any government not too strong for liberties of its people can be strong enough to maintain its own existence in great emergencies. If our federal government doesn't have the power or the capacity to be able to maintain its own superiority, then we don't have a union. We have the states that are more powerful than the federal government. And so that was the point in these states, because you mentioned that in the beginning there. These states, when you have one state that refuses to enforce the Constitution of the United States, the other states around it, its job is to act and require that state to return to its compliance with the laws, with the foundational law. So each one of these states, their duty and responsibility is to maintain that harmony, to not go and say we can do something different, and we're not going to follow the Constitution, and we're going to do whatever we want. That's not the role of the state. The state should be there to unite and to act as that buffer between the central government and people. So they've forgotten what it is. I think that in one of my responses to the court, I think it was maybe the rebuttal at the district court, what I said was that I'm appalled by the state's ingratitude of the sacrifices of great Americans such as Dr. Martin Luther King and President Abraham Lincoln, who gave all they had, including their lives, in battle for equality. For a state claiming to be progressive and cognizant of the plight of humanity, it is disturbingly regressive in its understanding of our nation's history, the application of our nation's laws, and its role in the governing of our nation's people. And I think that says a lot, because these states, they don't understand our nation's history. They've forgotten it. They don't understand their role in governing our people, and they certainly don't understand how our laws work, because they're refusing to recognize and enforce the supreme law of land, which, it is appalling to think that these states will claim to be progressive and claim to be cognizant and for the people, but yet go and oppress them in such a manner that it goes against all of our principles of Americanism, everything that we fought for, all of the blood that's died in sacrifice of this battle for equality. And I want to see the state step up, because it needs to happen.
Well, I think that's happening because of how exactly what you outlined, is that we're acting under judicial law.
Yeah.
You know what I mean?
And
so when you're able to go back to Barron versus Baltimore and cite that as law and as something to follow, this is an issue, which I want to say before I let you back in, and then we're going to get into self-incrimination. But after, since this is the Fifth Amendment, I think after this here, we'll make an episode on Barron versus Baltimore. We've been promising that to the people. So after this, our next get together, we'll do that.
Good.
And then we'll run some more amendments, and then we'll do another landmark decision that's affecting, it's essentially going against the Constitution.
Yeah.
Because I would really like to get into the federal crime bill and these things as well, Title 18 and such. But that's down the road. But so I'll let you speak, and then let's get into the self-incrimination.
Okay, so my case, I'm asking two questions, because you got to ask the court questions, and I'm not necessarily for that, because when we ask the court a question and we say, do we have this right, we're giving them the ability to decide whether or not we have it. I don't believe that we were meant to ask questions, but that's the way that they do it. I think that we should go to them and say, we have this right, please enforce it. Because the moment we ask questions, then they become the God. Then they become
You're putting the power in their hands.
Our rights, and that's not the way it works. We determine our rights, the people do, then we go to them to enforce those rights. So I don't like the idea of asking the court questions, but that's the format that they have. I'm not going to argue with that. I have two questions that I'm going to be asking the Supreme Court in my case. And these, I believe, are the two main issues that are driving all of these issues across the country. You know, the roots of tyranny and oppression can amass great evils. The roots come from these two things. So the first question is, do states have the right to substitute their own alternative legislation for the provisions and guarantees of the United States Constitution? Right? That's a rhetorical question. The answer is no. States cannot substitute their own alternative legislation for the provisions and guarantees of the Constitution. And as a result, all these state constitutions that say that they don't give a grand jury or that they don't do, those are all rendered unconstitutional. They're all nullified through supremacy. So that's issue number one. And that would mean that here in the state of Washington, for instance, Article 1, Section 26, it says no grand jury shall be drawn or summoned in any county, must then be replaced with the correct provision of the Fifth Amendment saying you must have it indicted by grand jury before holding them over. So that's number one. States cannot substitute their own alternative legislation for the provisions and guarantees of the Constitution. Okay. So the second question is does the judicial branch have legal authority to alter, amend, or destroy any of the provisions or guarantees of the United States Constitution? Again, this is rhetorical as well. The judicial branch does not have legal authority to alter, amend, or destroy the United States Constitution. That is the sole responsibility and duty of the people of the United States. So when you have Barron versus Baltimore, for instance, or you have Hurtado versus California, or you have any one of these other rulings where, Plessy versus Ferguson or Dred Scott versus Sanford, that are clearly unconstitutional. It's unconstitutional because the Supreme Court of the United States felt as though they had the power to alter, amend, or destroy the Constitution of the United States. You cannot declare the Constitution unconstitutional because the judicial branch has nothing to compare it to. So they can't come in and say, oh, that provision in the Constitution is not constitutional because there's nothing to compare the constitutionality of it. Right. We assume automatically that the Constitution is constitutional because it was ratified by the people. But once again, in order for laws to be legitimate, they must be considered just and equal. There is an element of the Constitution that was unconstitutional and violated the parameters of egalitarianism, and we have to get rid of that. And that is that all men are equal. There is no slave. There is no difference in black and white. There is no difference in man and woman or rich and poor. We are all equal. Every single one of us. We are all given our freedom and maintain it. So no question. The thing is, the judicial branch has no legal authority to alter, amend, or destroy the Constitution of the United States. And in doing that, that means that one, Hurtado versus California, which is the decision that was made that said that the states don't have to abide by the grand jury, don't have to use it, that they can use information instead. That is contrary to the Constitution, made by the Waite Court. And as a result, it's unconstitutional. And it will be rendered such that because the judicial branch, particularly Chief Justice Waite, had no right to say that the state constitution is more powerful than the federal constitution. When the state constitution says that they do it differently, you aren't to side with the state constitution, you are to side with the federal constitution. It will render that nullified. And then as a result of me being able to go through Hurtado, I can then attack Barron versus Baltimore directly because Barron versus Baltimore is still Supreme Court precedent today. And as a result of the deprivation of the right that I had through the Hurtado case, Hurtado is presenting to Barron versus Baltimore. I can attack Barron versus Baltimore directly, and thus we can reverse these hundreds of years of illegal and unlawful application of our fundamental supreme law. So my intent is to get rid of Barron versus Baltimore. And so you mentioned once again the state constitution. So I just want to say that when you have two different constitutions, you have a state constitution and you have a federal constitution. What that does is it creates two different citizenships, right? We've heard this before. The dual citizenship theory derives from the Dred Scott case. It is still fallout from that particular case. So in Dred Scott, they said that they told the individual that they said blacks are not people, right? And they told him to go back and argue with the state because you are not a citizen of the United States because you're not a person. So you have to go back to the state and argue with it. So that whole dual sovereignty or dual citizenship theory, that is espoused by Dred Scott. So when we have state constitutions and they're one way, and then we have federal constitutions, what that implies is that there's two different citizenships that we can be treated differently. So the state constitution can give us whatever rights we have. Therefore, when we're going through a state adjudication process, we only get what rights are within the state constitution. But in the federal side, we have all those. That's not how it's supposed to work, right? The Constitution of the United States applies to all persons within the jurisdiction of the United States. You're not suddenly no longer a United States citizen because you're residing within the state of Washington, and you're to be treated the same no matter where you're residing in the United States of America. So the Constitution of the United States is the only thing that matters. States were not supposed to have their own constitutions, because once they have their own laws, then guess what? They're enforcing their own laws, which means that they become a party to God. There's supposed to be one unified set of laws, and that was to derive from the United States of America, from the representative government, and federated out to all the regional governments for administration. We weren't supposed to have state laws. Well, state laws that people are bound to. So that's what I got. Yeah.
So going into self-incrimination, I'm going to read a little bit coming out of Cornell Law of what they say about it. And what it says is, the Fifth Amendment also protects criminal defendants from having to testify if they may incriminate themselves through the testimony. A witness may plead the Fifth, quote unquote, and not answer if the witness believes answering the question may be self-incriminatory. In the landmark Miranda versus Arizona ruling, the United States Supreme Court extended the Fifth Amendment protections to encompass any situation outside of the courtroom that involves the curtailment of personal freedom. Therefore, any time that law enforcement takes a suspect into custody, law enforcement must make the suspect aware of all rights, known as Miranda rights. This is what we see in TV when they say, did they read his Miranda rights? Did he meet, that's what they mean. These rights include the right to remain silent, the right to have an attorney present during questioning, and the right to have a government-appointed attorney if the suspect can not afford one. However, courts have since then slightly narrowed the Miranda rights, holding that police interrogations or questionings that occur prior to taking the suspect into custody does not fall within the Miranda requirements. And police are not required to give the Miranda warnings to take the suspects prior to taking them into custody, and their silence in some instances can be deemed to be implicit admission of guilt, as we talked earlier about. If law enforcement fails to honor these safeguards, courts will often suppress any statements by the suspect as violating the Fifth Amendment protection against self-incrimination, provided that the suspect has not actually waived the rights. An actual waiver occurs when a suspect has made the waiver knowingly, intelligently, and voluntarily. To determine if a knowing, intelligent, and involuntary waiver has occurred, a court will examine the totality of the circumstances, which considers all pertinent circumstances and events. If a suspect makes a spontaneous statement while in custody prior to being made aware of the Miranda rights, law enforcement can use the statement against the suspect, provided that police interrogation did not prompt the statement. The Fifth Amendment right does not extend to an individual's voluntarily prepared business papers because the element of compulsion is lacking. Similarly, the right does not extend to potentially incriminating evidence derived from obligatory reports or tax returns. To be self-incriminating, the compelled answers must pose a substantial and real and not merely or trifling or imaginary hazard of criminal prosecution. After Congress passed the Crime Control and Safe Streets Act, some felt that the statute by implication overruled the requirements of Miranda. Some scholars also felt that Congress constitutionally exercised its power in passing this law because they felt that Miranda represented a matter of judicial policy rather than an actual manifestation of Fifth Amendment rights. That's Cornell Law.
So the whole point in the Constitution, remember, is to establish rights and limit powers. People have rights, government has powers, okay? So we want to preserve the rights, and we do that by limiting the powers, by making it so that there's checks and balances that are in place and limitations that are imposed upon the individuals, law enforcement, and everything that's administering those laws. So we limit the powers in order to preserve the rights. Okay. We don't do it the other way. So you don't preserve the right or the powers. You don't make it so that they're easier to maintain or easier to get around, because that would then be at the detriment of the rights. So that would go against the constitutional theory, the constitutional belief. We're not protecting government. We're not protecting the prosecutors, because here in our system of government that sometimes a guilty person may appear to be set free, but we have a system that if it works properly, innocent people will not be punished. But today we have 15% of the people in prison that are innocent. And we have that because we're not following the rules, because we're making it so that government is protected. That's not what the Constitution is meant to do, right? We shouldn't be doing that. We need to protect the people, because the most important thing here in America, the thing that makes us unique, is that innocence was not meant to suffer. We have a system that if it's used properly, innocence won't suffer. But if it's not used properly, then guess what? Then you have what's called legal realism, which is the belief that judges make the laws, and it's not based upon a formal set of rules or principles, but instead upon individual judicial decisions that's based upon their own social, political, or public policy. So when you have judges that believe that they can make rulings, or lawmakers that believe that they can make laws that are contrary to the Constitution, you have what's called legal realism, which is not constitutionally based. It does not permit fair and equal treatment of people. Now, legal realism has always exposed the political nature of laws, always, and in the absence of due process, you have innocence that suffers because of legal realism, because people are not being treated equally and fairly. So, legal realism all through history, you can point to it and you can see the political and oppressive nature of the law that was created, or the ruling that was created as a result of someone's social, political, or public policy. So when the Weight Court wants to actually advance and proliferate the slave institution, then they do that through legal realism. And that shows, once you historically look back at it, you can see the political nature of the law, because it had that intent. But so the rules of civil procedure, it specifically states, now this is also in correlation with Miranda, but this is directly out of the rules of civil procedure. But it says rules, which come from judges, right? Rules must not conflict with statutes. Those are laws written by people, or impair the legal rights of the parties. Legal rights of the parties would be the constitutional rights. Thus, a court has no power to declare a rule that shall constitute a waiver of a constitutional right. A court cannot create a rule that shall constitute a waiver of a constitutional right. So when a judge says to you, do you want to waive your right to a speedy trial, or do you want to waive your right to a jury trial? According to civil procedures, guys, can't do that. Rules cannot conflict with statutes, because rules don't change laws. Laws are made by the people and rulings are made by judges, but judges are tethered to positive law, the law made by the people. Otherwise, they're acting unlawfully outside of the law itself. And that's arbitrarily. That's a government of man, as opposed to a government of laws. We're supposed to be a government of laws. We're supposed to be governed by the laws that we create here, govern us. But instead, we have a man that says we're not going to do that, and we're going to do something different, and thus created a waiver of a constitutional right. The judge can't ask you if you want to waive your right to anything, because in doing so, it would have impaired the legal structure, the statutory obligation that exists, that was established by the Constitution. That's why I say that our rights can't be waived. They can be taken away. They are unalienable, because before we have that right to use or to waive, the judge has already breached his duty to act and to ensure that you're guaranteed it. A breach in their contract does not entitle them the right to be able to go and breach your contract or establish a new contract with you. If the judge has to breach his oath of office, breach his contract that he established, saying that I will do what the Constitution of the United States says, if he has to breach his contract in order to get you to plead guilty and establish a new contract with you, that makes the second contract illegal, because it derives from the breach of contract number one.
Right.
In constitutional law, so contract law, you can't do that. The judge can't breach one contract to enter into a new contract without.
Well, it's in the same sense as criminal law as well. I mean, wherever the error occurred at in the process, anything, it doesn't even matter if you follow judicial law behind that error, it's still an error. You have to go back to the original error and fix that error, and everything behind that is redone.
Exactly. So, you have what's called progeny, right? And we use what's called case law here, right? And we talk about it all the time, common law, right? English common law. So common law is based upon case law. Case law is the lowest form of common law, right? It's judge-made rulings. And so once again, if we were a government of laws, and the government of laws doctrine, meaning that the laws are superior and everything derives from them, the Constitution is the foundation and everything's built upon it, then that would mean that the highest form of law, or the supreme power, would be the Constitution of the United States. And we would go to it to determine whether or not a violation of your rights have occurred. But that's not how it works, is it? Right? The way it works is if I file a complaint of a constitutional violation, they go to case law. They go to the lowest form of law to determine whether or not my rights have been violated, which means that their oath is not directly with the Constitution of the United States like it's supposed to be, but instead upon the judicial ruling of the judge that came before them, or the flawed decision of the judge that came before that judge. So they're going to the wrong location. Case law and stare decisis was not meant for a government of laws. It was meant for civil law and not criminal law. Criminal law was supposed to be based upon procedures and processes that are defined so that every single person involved in the system will result in the same process, the same adjudication. But when they go and they use stare decisis and they use case law, then that means you can treat them however you want, because you can always find a case that will side with whatever it is that you want to determine.
Right.
It always happens. So stare decisis.
And that's how you get a man in Arizona sentenced to 7 life sentences for marijuana.
Right. Yeah. And once again, so Article 4 of the Constitution, it says, the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. So when you have a state and you have the federal government that allows for the state of Washington to legalize marijuana, or down in Oregon where all drugs are legalized, last year they legalized every drug, right? Decriminalized it all. And guess what? That means that there's privileges.
They decriminalized it. They didn't legalize it.
They do. Well, they legalized it. They're not prosecuting, which means that they're lawfully able to possess it, heroin and all the rest.
But you can't buy it. That's the thing. You can't go into a store and purchase it.
No.
But you're not charged with it if you have it on you.
Right. So that's an immunity, right? So privilege would be you can go in the store and buy it. And immunity is that you're immune to it. You're not going to be charged for it.
Exactly.
So all privileges and immunities of United States citizens shall be equal all across the United States. So when the federal government allows or permits the state of Oregon to create a law that says we're decriminalizing these drugs, guess what? Someone that's arrested in Ohio, all you got to do is say, wait a second, now Oregon's got an immunity that I don't have, therefore you can't charge me with this offense. As long as the federal government permits the state to come out and create those laws and doesn't pull supremacy in order to maintain that unity, then guess what? All citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. If one state and one United States citizen has one immunity in the state of Oregon, then every single United States citizen in every single jurisdiction in the United States has that same immunity by law and by Constitution. Because remember, in order for laws to be legitimate in our system of government, they must be considered just and equal. Every single person is treated the exact same way by laws in an egalitarianism type of government. That's what we established. That's what we chose. And so as a result, you can't have a person in the state of New York, being denied a right that's secured and enumerated and guaranteed to individuals in the state of Ohio. Can't do it.
Right. But yet a prosecutor can go in and cite a judge's opinion from another state.
They do it all the time. Yeah.
You know what I mean? So you can go in and cite a judge's opinion from another state and what was applicable in his state, but I'm not privy to that state's laws, whether it's the decriminalization of drugs. So if I get caught with meth here in Florida or crack or heroin or anything like that, I'm going to be charged, and I can't say, well, they do it in Washington or they do it in Oregon. That's not going to be applicable to my case. However, they can go into Washington and cite a judge to criminalize me or penalize me.
Well, it actually would be applicable if we actually were following the Constitution, right? If the states weren't allowed to have their own laws and to govern their people their own way, because remember, states' rights has always been code word for segregation or discrimination. So when you allow for states' rights to exist, that means that the states have the right to govern however they want, and that causes segregation. It causes the ability to.
I like that. I've never heard that before.
Yeah, the states' rights have always been code word for segregation. All through history, when you say states' rights, it means segregation. It means the ability to treat citizens differently within the local region, within the location. But states' rights derive from a case called Santa Clara Railroad Southern Pacific Railroad versus Santa Clara County. And so in that particular case, it happened before the oral arguments even started. But what was said was that, and it was under, I believe, the Fuller Court, I believe. But anyway, what was said before the court heard oral arguments was they said that we're in agreement that the 14th Amendment applies to this organization. So they were saying that the 14th Amendment, which is what binds the states to the Bill of Rights and makes them enforceable to the people. They were saying that now this corporation, being the Southern Pacific Railroad, now has the protection of the 14th Amendment. What that did was it said that corporations are now people, right? And it gave corporations the protection of the 14th Amendment, which meant that they now have rights, right? They're protected like people, so they have to have equal protection and all the rest. And that's carried on for years. It still is today. The corporations can be treated as though as a person. They have rights. But the thing is that a state is a corporation. So right. The whole point in making that decision was to give states rights, because rights are more powerful than powers. So when we talk about states' rights, it derives from that particular case where they said, yep, this railroad, who's a for-profit business, is protected by the 14th Amendment. And the states just said, awesome. Well, now we have rights because we're a corporation.
That's exactly right.
They have rights, guess what? They can now own property, right? And slaves are private property protected by the Constitution, driving from the Dred Scott case. And that was the whole reason in making that decision, was to memorialize the Dred Scott case. I've been saying that all along. These rulings have been put into place particularly to memorialize Dred Scott and memorialize the slavery institution, and to make it so that the slaves cannot sue the slave owner in federal court for their freedom. Which is where
I want to break down a whole nother episode with you on straw man, which is straw man comes in and how each of us are looked upon as a corporate entity. This is why our name is in all capital letters on our birth certificates. This is why we have social security numbers. This is why we are a corporate entity.
Yeah. So another thing that I say often is that if you want to predict the future, all you have to do is study the past, right? So history will always tell you, what's happening. And so if you look at history and we look at where we're at today, where there's Dred Scott and, this division and dual citizenship and everything that's going on, we look and we say, all right, Plessy versus Ferguson, the segregation issue, which we're experiencing as well. What changed that? What fixed that? Well, it was Brown versus the Board of Education, right? And what did Brown do? Well, Brown established what it is personhood. They said this is what personhood is. So we're dealing today with this corporate issue where corporations are believed to be a person, right? And they can own property because the slaves are private property. So they wanted to do that in order to advance the Dred Scott case. And so if that's true, then we can look at Brown versus Board of Education. We can see what did they do to win their case. And we can actually present a very similar argument because history is simply repeating itself. Well, in the Brown versus Board of Education case, they had 4 requirements for personhood, right? They established them. And the very first one, no state can abide by. And that is they must be self-aware. States aren't self-aware. They're not aware of anything. Therefore, they can't be a person. And that's already been established by the Supreme Court of the United States. And so for years and years and years, we've had these corporations in these states have been able to say, we've got the right to do what we want because we've got rights, and they have rights because of this case. Well, you're not a person, state. You have powers, and we need to bring them back and say, no, your powers are limited. So, we don't want states to have rights. We don't. Government has power, people have rights. We need to maintain that. So that ruling from Santa Clara Railroad, it is absolutely contrary to the Constitution, and it was put into place to proliferate the slave industry. Because once again, you had Hans versus Louisiana that said that you don't have the right to be able to sue your state in federal court, right? So that was the first one. So it made it so that the slave can't sue the master, the new slave master, in federal court. But then they had to make it so that the state was able to own property, because a corporation can't own property. A person only owns property. So they had to make the corporation's person in order to preserve the property, in order to make it so that you can't bring them into federal court and sue them. That's the whole point in these cases. Those 2 cases right there represent the biggest barrier between a constitutional violation and deprivation of rights and restoration of those rights, restoration of freedom. Those are the 2 barriers between most civil rights cases across the United States, and yet people aren't talking about them because they don't understand the historical underpinnings to it. So this incrimination, self-incrimination clause, it's really important. But the thing is that the way that our Constitution works is that it's not necessarily an outdated document. There are still rights and freedoms that are within it, that are embedded within it, that we don't even know about, that we're still learning about today. Like my case is bringing up a couple of establishment of rights right now that we weren't even aware of. Like every single one of us has the right to go to the Supreme Court of the United States and demand that they hear our case, because there's a duty established by the Constitution of the United States making them responsible for hearing our cases. When it says that in all cases which a state shall be party, the Supreme Court shall have original jurisdiction. That means that the United States Supreme Court must hear our case if our case derives from a state, right? And as an obligation, because that's what the Constitution creates, an obligation, the Supreme Court doesn't have the right to disregard the obligation without violating our rights. Because remember, the breach of obligation results in a violation of the right. Our rights derive from those duty to act. So when I go to the Supreme Court and I say, you have a duty to hear my case because it derives from the state and the Constitution establishes that obligation, if they refuse to do it, we then have a right established. Because guess what? Rights derive from those duty to act. They have a duty. It's established. We have to show that they have a duty, and as a result of showing it, then they have to fill it. So our rights are constantly popping up, and they'll continue to pop up for as long as we're in existence, as long as the Constitution remains, because there are things in there that we don't even know about, because we live in an incident-driven society. So it requires an incident in order to create the change. Right. Our country doesn't just wake up one day and say, we're going to do things differently. It requires a reason, right? And that reason, it's only one person, one case. One case creates this reason, this incident that then drives the change. And then America is able to evolve and become more just or whatever because of the incident. So within an incident-driven society, that's how it works, is that we don't know what our rights are until we actually have an incident that occurs that drives, the change and the change in thinking. So we learn from our mistakes, but we learn from the mistakes of the people, because that's the only way the nation can learn. So now, once again, so the concept of the self-incrimination, they point at law enforcement doing an interrogation, but remember that prosecutor is the highest law enforcement officer within the county or within the area, right? So their job is still the law enforcement. They're still the investigators and so on. So, Miranda versus Arizona dealt with police officers, with bringing them into a police station, and that it created enough fear and intimidation simply being within the police station, all these officers around with guns and hard uniforms, and that created enough pressure on this individual that it would compel them to make statements that would not necessarily be correct in order to ease up the pressure, right? Because when you're under pressure, you're being intimidated. You want to get that, to remove that intimidation. You want to make it go away. And so you'll take every opportunity to get out of it, to get out of that pressure and to relieve yourself of it. So, the Supreme Court decided in Miranda versus Arizona that you can't bring someone in and interrogate them, without their consent, without them being willing to, because otherwise you're going to come in and you'll get involuntary statements. So
you'll get waterboarded. You'll get all kinds of shit.
All kinds of stuff. Yeah. So now think about it, right? How is a jail any different than a police department? A jail is worse because they've taken your whole freedom. You're in cuffs.
Hold on, Tanner. I lost you.
Go start.
Okay, I can hear you now. Okay, the last thing I heard was the jail.
Okay, so a jail is no different than a police department, right? So Miranda versus Arizona was dealing with the police department. They'll bring you in, they'll interrogate you, and so on. Well, when you're arrested and you're brought into jail, before you're even interrogated or talked to, and then they put you through these tactics to threaten and intimidate you by hauling you around in handcuffs, by getting you out of your own clothes and into their uniforms, by not feeding you enough, by putting you into a cold location, locking you down 23 hours a day. Each one of these are designed to create fear and intimidation, and to get you to comply with their wants and desires. So then you have the highest law enforcement officer that indirectly processes that threat to you, right? And it comes through your public defender, your attorney. That attorney will come up to you and say, well, I got a great deal for you. If you'll just plead guilty to this, she'll drop the 5 charges over here, right?
Yeah.
Well, you're already under those pressures. So once again, robbery and extortion are very, very close to one another. They're very close to one another in the spectrum of crime. Okay. A robbery is establishing a contract through illegal means with the threat of immediate bodily harm. Okay. Immediate bodily harm. So that would be robbery. Now, my case presents what's called the formula of intimidation. And everybody, you want to learn this. Okay. The formula of intimidation goes like this. And all intimidation follows this formula. It says, if you don't do X, I will do to you Y, whereby X is my envisioned outcome and Y is a result of my powers can cause. Okay. So let's use robbery, for instance. Now, I have the power to bear arms. If I go and buy a gun and I point it at you and I employ the formula of intimidation, it is, if you don't give me your money, I will shoot you. Right. So I'm formulating a contract for your money. Right. That contract is put into place, but I'm doing it through an illegal means because I'm using the threat of duress or harm, immediate bodily harm to you. And therefore you establish a contract. You give me your money through an illegal means. That is a crime called robbery. Right. Okay. So my envisioned outcome is I want you to give me your money. A result of my powers and causes, I will shoot you and you will die. Therefore, you give me your money not out of willingness and volition, but as a result of the fear or duress that I've inflicted upon you, right? That would be robbery. Now, extortion is to establish the contract through illegal means with the threat of future bodily harm, okay? Future bodily harm. So if I'm a prosecutor, I have the power to send you to prison. I have the power to give you charges, right? So if I employ the formula of intimidation, it goes like this. If you don't plead guilty, I will send you to prison for 20 years. My envisioned outcome is I want you to plead guilty. A result of my powers and causes, you will go to prison for 20 years. You decide to plead guilty for 1 year in order to avoid the 20 years because of the fear or duress that I've inflicted upon you. The contract that I've established is to take your life away, not your money, but your life. And I do it through an illegal means because of the threat of future bodily harm. It's extortion. You are establishing a contract through illegal means. And the thing about it is it's not up to the judge to determine whether or not you've been intimidated, right? When you have witness intimidation, do they question that witness? Do they say, their witness? Do they say that you didn't? No. All that has to happen is that witness say that they were intimidated by a statement that you made to them. That's it. Yep. And that's because intimidation is an inward manifestation and not an outward manifestation, right? If a judge asks me to show him my intimidation, I can't show him it like it's scratching my arm. It's inside of me. Something happened to me. I know I was intimidated. I know that you threatened me. And as a result of that threat, I pled guilty to something that I wouldn't have been found guilty of. And you did it through the use of a discretion, abuse of discretion, abuse of your power. Yep. That is actually crime.
That's what I'm dealing with in Mississippi with the case of Curtis Davis Jr., where he was essentially threatened and coerced into pleading to manslaughter. If not, he was going to be charged. His wife was going to be charged with first-degree murder, and that he would never see his son again. That was the coercion. So he ended up signing to manslaughter.
Right, and so when you say to someone that I'm going to put your wife into prison and I'm going to take your son away, if you went into a jury and you said to that jury, I was threatened and intimidated and pleading guilty, and you pose that question to the jury, there isn't a single juror that wouldn't say that they wouldn't feel as though, even if they didn't decide to plead guilty, that it wouldn't make them think about it, right? And even the process of tampering with you is still a crime. Tampering with witnesses is still
I honestly, Tana, I don't think a jury would know. I think a jury would ask the question, well, if you're guilty, then take the manslaughter. You know what I mean? I think that's where the American mindset is at these days, is that when the government says it, it is true.
So when I was bringing up my defense strategy for my trial, my whole strategy was this, right? Was that my wife and I, we didn't want this no contact order. We wanted to be married. We were gonna maintain it for 2.5 years. During all this, we were fine. But it was the prosecutor that came in, and they didn't want me to be at home. They wanted to break this up. They wanted to send me to prison and make me stop saying the things that I was saying. So they put the no contact order into place between us. So this criminal element that removed any sort of communication that I could have in order to maintain this relationship with her. But my whole defense strategy was that I was going to use the jury as basically a grand jury. And what I was going to do is I was going to say that my wife didn't want this no contact order. The state put it into place. And then this prosecutor came up to me and said, if you don't plead guilty, I will send you to prison for 3 years. And that caused me to plead guilty to something that I would have never been found guilty of. So if I were to pose that to these jurors, and I were to say to them, listen, if I said to you, if you don't plead guilty, I will send you to prison for 3 years. If you think that would at all influence your decision or make you even think about it, you must find me not guilty due to self-defense. I was simply imposing self-defense, and I'm defending my family against this malicious prosecution from this prosecutor who put something into place that neither of us wanted, right? And so the thing is that I would have gotten a juror, to at least one juror, to say, yeah, that would have threatened me. I would have probably gotten every single one of them to say that yes, that would influence my decision, because all you have to do is just put it in your mind. They're taking everything away from you. You just lost your house. You lost your wife. You lost your kids. Everything is gone. And it's gone because this person is telling you to do this. And you could get out today if you would just say that you're guilty. That's all you got to do. And if that would at all influence your decision and cause you to say that you're guilty, or cause you to think about it, you must find me not guilty. Now, they found out about my defense strategy, and that's why they wouldn't allow me to testify. That's why they wouldn't allow me to cross-examine witnesses, because they knew that I would win. Because the moment that I'm found not guilty in that particular case, guess what? I'm not guilty because the prosecutor committed a crime. That's what that jury would have determined. I'm not guilty because witness intimidation occurred, and now I can say to that prosecutor, you're under arrest. So they didn't want me to do that because they knew that I would have won. I would have presented it to the jury, and the jury would have nullified the law as a result of finding me not guilty. And so they wouldn't allow me to testify. They wouldn't allow me to call witnesses. They wouldn't allow me to cross-examine witnesses, and as a result, they completely destroyed my my defense strategy. But so the point is that there's certain elements of a contract, right? And so when you look at consideration, right? Consideration deals with the value of the contract. So you have to have, in order for a contract to be valid, you have to have the ability for the contract to be represented properly, right? So you have to have the ability to be able to negotiate on both sides. So when the government comes in, the state comes in and says, if you don't plead guilty, I will send you to prison for 20 years. Where in that is the option of being not guilty? You're either guilty or you're very guilty, right? There's no in between. There's no not guilty. And as a result, there's no contract advantage for me, right? For the individual. And that makes the void contract. It's the consideration doesn't exist because of the excessive power that exists on one side of the contract over the other. You know, if we had the grand jury once again, and the grand jury determined that you can only charge them for an assault 4, you can't charge them for assault 2. Now I know what I can negotiate with. Now I know that the grand jury believes that it's this crime. Now I know exactly what I'm working with. But if I don't know what I'm working with, and they're able to charge, all these charges, then guess what? Then that means that they come at me with this obscene amount of time, and I have no negotiating power. I have no ability to win in the negotiation, and so it makes the contract uneven. So you can't have that, and you have to have contracts that and the ability to contract independently and maliciously. You have to have the ability to contract on your own and make decisions on your own behalf, and they have to be in the best interest of all parties, not just a single-sided party. So the grand jury clause, or the self-incrimination clause, what it says no person shall be compelled in any criminal case to act as a witness against himself, right? So the whole plea bargain issue derives from this particular clause, right? So what it says is no person shall be compelled, and Black's defines compelled as to bring about through the use of threats or intimidation. So when you use threats or intimidation to bring about an end goal, you are compelling someone, okay? And it says in any criminal case, so that would be a misdemeanor or a felony. So anytime that you are compelled, threatened, or intimidated into pleading guilty, you have violated this particular clause. And the reason why is because when you plead guilty, down at the bottom of that plea bargain, it says, I did certain things, and you sign it, which means that you are acting as a witness against yourself. You are the only witness. And the way that they get you to do that is through the use of threats or intimidation. Plea bargains are unconstitutional. They are illegal. They are a violation of the self-incrimination clause because of the threats and intimidation that's been applied from the prosecutors and judges and the whole system itself in order to get you to plead guilty through the abuse of discretion, through the abuse of power. And there's no denying it. So, this is what they want. This is what they do. And there's no practicing law anymore. These prosecutors, they don't know how to argue a case.
Right.
They don't. They don't practice law. Intimidation is not practicing law. But 98% of all convictions come by way of plea bargain because they don't want to have to do it any other way. They just simply want to push the numbers. And so
that's right. That's
so you have
exactly
to understand
right. And they're working off percentages, and because there's immunity, there's no repercussion. So what do they care? You know what I mean? They're just working off percentages. They just want to keep them passing through, and whatever they can get. That's
Yeah, there's an interesting statement, and I think it came from Thomas Jefferson, if I remember right. But it says that it's talking about the reason for having the speed and efficiency. So speed and efficiency is used when there's an absence of due process of law, right? So you use speed and efficiency as opposed to the structured legal process when you want to speed up. So the absence of due process of law is used in the case of they want to speed things through. They don't have enough time to deal with all these offenses and all these charges, and so as a result, they focus on speed and efficiency, which results in the deprivation of the due process or a violation of the due process. If they utilized the structure or the actual defined process, then that would result in a much less speedy process. They wouldn't have the speed and efficiency that they have otherwise. So it actually draws the comparison between the two. So when you have speed and efficiency being the focus, like they have today, because they have so many charges that they can't do it any other way, that results in a deprivation of the due process or a violation of due process as opposed to the structure. But we want the structure because that's the only way that we can have consistency in laws and consistency in the way that people are treated.
Well, T, what else you got?
So once again, we mentioned that progeny. So progeny is they're rulings that derive from another case. Okay. So when the Supreme Court of the United States, when they come out and they make a ruling, that ruling then applies to all of the regional governments. They all have to implement that rule. So, if the Supreme Court comes out tomorrow and says that that you have to have a grand jury, then every single court within the jurisdiction of the United States would then have to adopt that particular rule and put it into practice. Okay. So when the Supreme Court of the United States comes out with an unconstitutional ruling where they're clearly acting in violation of their oath by siding with the state constitution, for instance, or going against what the Constitution itself says, they are in fact making an unconstitutional ruling, and that ruling then flows out to all the regional courts for administration, right? And they must follow that new rule, which means that every single case that derives from that is also rendered unconstitutional. So when you have Barron versus Baltimore from 1833, it says that the Bill of Rights doesn't apply. We can point at that. We can say that is unconstitutional because, one, the Constitution says that this Constitution is the supreme law of land and shall enjoy legal superiority over conflicting provisions of state constitutions. We can also point to the judges in every state being bound thereby anything in the Constitution, or laws of the state contrary notwithstanding. So we know that the Bill of Rights, when they were ratified by the people on December 15, 1791, as of that moment, they became part of the United States Constitution in all intents and purposes. And as a result, they are applicable no matter who you are, where within jurisdiction of the United States, because the judges in every state are bound to do it, right? So my point
is stays in place until the people unratify it, correct?
Until the people change or alter it. But for them to come out and say that it doesn't apply to states, that said to the judges in the states, hey, you guys don't have to follow this, which is a violation of the Constitution, right? Because the judges in every state are bound thereby anything in the Constitution or laws of any state contrary notwithstanding. So when the Supreme Court comes and says, state judges, you don't have to do what the Constitution says, that is an unconstitutional ruling without a doubt. There's no arguing it and there's no justifying it. So what happens then is that any case that comes from that, derives from that ruling, is also going to be rendered unconstitutional until that ruling is removed and the correct ruling is put into place and the system is brought back to harmony. So as of right now, because the Bill of Rights applies to the criminal adjudication process, right? Every single thing within there all applies to how you make a criminal, right? That means that as long as Barron versus Baltimore remains standing Supreme Court precedent, which it is today, as long as it is, then that means that every single criminal conviction in every single jurisdiction within every single state and every single court is rendered unconstitutional as well because they are tainted by the illegality of the way in which they were obtained. If the root is unconstitutional, then all the fruit coming from it will also be unconstitutional, right? If the Supreme Court of the United States makes an unconstitutional ruling, then every single case, every single criminal case is progeny to it. And that means that every single criminal judgment in the United States is unconstitutional. And you want to know, that's the reason why.
That's the standard that we're held to.
That's the standard we're held to. But listen, every single day, cases are overturned and rendered unconstitutional because of an error, because of an issue. Those are normally procedural issues that are determined through an appellate process, right? But this just happens to be a facial constitutional violation on its face, meaning that it's not even procedural. It is written right there and is black and white. It's clear as day. It's a per se violation. And as a result, there's no real argument in it, right? But the problem here is that this affects so many people. But the thing is that every single day, convictions get overturned because they're unconstitutional. It doesn't matter whether it's one person or it's a million people. If it's unconstitutional, it's unconstitutional. And that's what we need to remember, right? They're employing what's called standard. They're trying to keep us from getting this into the Supreme Court by doing everything that they can to make it go away, right? If this were about just me, if I would have made this just about me and the error that was made in my trial because of that judge's actions, I would have been done a long time ago. They would have paid me. I would have went away. They would have never messed with me again. But this wasn't about me. This was about everybody, right? And we have to make that about everybody because, listen,
don't blame us. Blame the government because they know what they're doing.
We're all being deprived of rights every single day. Every single one of us. We all have cases that we want to talk about. I want to talk about my case all day long. But the thing is that when I talk about my case, that's about me, right? We can settle this issue when we all turn together and we focus on the root problem and we put our voice there as opposed to our voice over here. Then guess what? Your situation, your problem, your case and your deprivation of rights, they derive from that. Mine derives from that. If I talk about mine, we're broken up. But guess what? When we all focus and we all start talking about the same thing, now we've got power because we're all talking about it. We're all pointing in that direction, and you can't make that go away. We need to stop talking about our individual cases. We need to start focusing on the main issue. And when we do that, when we put our voices there, that's when we're going to see change. That's when we're going to see power because they won't be able to make that go away. If we're all talking about the same issue, Barron versus Baltimore, guess what? Barron versus Baltimore is not going to stand. It's not going to be there. The American public won't allow it.
Amen. And if you went and you asked 20 people right now about if they were familiar with that case, how many do you think would say yes?
Not one. I have a master's degree in law. I didn't know about it.
Right.
Until I got into the system involved. That's where I learned about it. This is the misinformation that exists.
Now let me say this right here on what you just said, because what you just said speaks volumes. And I've been dealing with that for the past week, right? Is this younger generation. I was surrounded by this younger generation for a while, and they're beautiful people. So I'm not calling anybody out in particular, but it's the mindset of the younger generation. And it's what you just said, because I had a certain individual that was trying to quote unquote make me understand something. Now, this individual was 25 years old, right? I'm 46. How is a 25-year-old going to make me understand anything other than your own personal experience? You know what I mean? Because all you're trying to tell me or quote unquote make me understand is something that you've been taught. What I'm trying to get you to understand is the experience that tells you that what you've been taught is not real life.
Right.
You know what I mean? And that's exactly what you just said. You just went through criminal law and you didn't even know about Barron versus Baltimore until you experienced it. You know what I mean? And had to research it on your own. And that is exactly what I'm talking about when it comes to that. So, you know, you can have all the knowledge in the world, but if you don't have the experience in that field of knowledge to determine whether what you learned is right or wrong, then all you have is that knowledge and you don't know whether it's right or wrong.
Right. So Socrates and Plato and Aristotle, you know, all of the ancient philosophers, they all believed in something that was called pharnesis. Pharnesis is practical wisdom, right? It's practical wisdom. And they said that it's something that can't be taught, but it must be learned from experience. But it's the highest virtue that man can achieve, right? Mm. Most men aren't able to do it, but you get it from experience. You don't get it. You can't be taught it. You can't go to school and learn it. You have to learn it out there. And so for me, I didn't know anything before this happened. I was never challenged or tested until this. I didn't know anything about courage or strength or power. You know, I had money and I made money and I was free and I lived an easy life. But I didn't start learning anything in life. I didn't start learning any wisdom until this came up, until I started getting tested, right? Trials and adversity, don't look at them as though they're terrible, awful things. Look at them as an opportunity to learn and to actually become something. Because those trials and adversity, those are where you're going to teach. The seeds of wisdom derive from trials and adversity. That's where they come from. You want to get wise? Go and live it in your life. That's what Socrates was referring to when he talked about pharmacists, right? The things that I say, I'm able to say them because I've experienced it, because I've been there, I've lived it, I know what they're going through, and I'm now able to express it in such a way that people can understand it. And that's pharmacists. That's practical wisdom. That's the virtue that Socrates and Plato was referring to when they said that it cannot be taught, it must be learned from experience.
That's exactly, and that's it. It's in a nutshell. So beautiful, beautiful discussion, man. Amendment 5, the Constitution. Our next episode will be Barron versus Baltimore. So I'm gonna actually spend some time in reading that, because I don't know anything about that other than what you've mentioned several times. So I definitely want to come into this conversation prepared and armed. So I'm gonna take some time into reading that and get ready for that discussion. But Tanawa, thank you again. First, I really appreciate the time that you're investing in, one, just trying to bring awareness to our American citizens, for two, that you've chosen my platform to do this with, and three, for teaching me, because I've learned an exponential amount of information from you, and it's making me see things a lot more clear. So I really appreciate, because what I want the listener to understand and appreciate is the trials and tribulations that you yourself have gone through to learn what it is that you've learned, and you're sharing that with us free of charge, just because you care about us. So that is the appreciation that I'm awarding
Well,
you.
I thank you for that. And I really appreciate it. For me, this has been, it hasn't been easy, but I see the blessing in everything that's happened to me. I mean, as bad as it is, the taking of the children, they're going to be proud of me because of the things that I've done. And I know that, and I can accept that. But, I didn't come to you. God chose you. This is the platform that he wanted me to use. And, and there's specific things that he has me, and I can see it every day. And when we look at like what's going on across the country and the things that are being said, you go into TikTok, and like I posted a video this morning. That video, you should watch that, because every single thing that I'm talking about, the jurisdictional issues, everything, it is all covered within that video. It is absolutely amazing. And they go into statutes and point to it. The thing is, once you know what God is doing, and you know that God's real, you will see him in every single thing. You'll see him all
Everything.
over the place. And once you see him and you know what he's doing, you see everything starting to work together. I mean, I'm in prison, I'm fighting, and I'm building a case for the ending of slavery at the same time that the movie The 13th was being produced and manufactured, and it came out at the same time. I mean, all these things happening in conjunction with one another didn't happen arbitrarily. People weren't working on things at the same time that I'm working on a case, so that all these things can come together at the same time and this issue can get resolved. That doesn't happen unless there's something
right
behind it.
And I want to say this: knowledge in self and knowledge in God not only helps you acknowledge and see God in everything, but it also helps you acknowledge and see the devil in everything as well, because you know who God is, and therefore when the devil is in front of you.
And that's a great point. And that's something I've said many, many times, and maybe I haven't clarified it, but if you read the Bible, right, and you look at the attributes of God, God's love, that's all he is. So if you love, you know God, right? But the thing is we know the attributes of God. He says, release the prisoners. He doesn't want prisoners. He says, your sins are forgiven, right? You don't need to be reminded of them, right? He says that he doesn't want you in a dark cell. Bring them out. He says, lighten the yoke of those who work for you, right? He's saying those things. Those are attributes of God, okay? So if those are attributes of God, Satan is going to be the opposite, right? So when I say to the court, I say, I know what side I'm on, because those are the attributes that I'm standing for. Those are the things that I'm demanding that we do as a nation. Those things that the Bible says that God would want done. I'm saying, release the prisoners. I'm saying that I know what side I'm on. So if I fight for God and the courts do the exact opposite, because they say, lock the people up. They say, you're a sinner, you're a felon, and we're going to remind you that you're a felon for the rest of your life. They say, put them into a dark cell. They say that send them to the hole because they missed the daily quota. They say they're our property, we're enslaving them. Who do they work for? if I work for God and I'm fighting for him and they fight against me, who is it that they're working for? Once you know the attributes of God, you can see who's working against you, because those are the ones that are going to argue with you.
Absolutely.
They're not what we think that they are, everybody. They're not what you think that they are, because the temple has been built upside down.
And the thing of it is it's so blatantly in your face now. Now it's like it's almost like they've been preparing for this, right? They've been establishing all the moves, and now it's like they're just making their move now. You know what I mean? Because it's so blatant in your face. I mean, we have a president that is trying to nominate a Supreme Court nominee that, when questioned about the Constitution, couldn't even answer the questions. You know what I mean? So it's and this is a Supreme Court nominee. Like, how scary is that?
Yeah.
That makes you almost question how much do the other ones really know the Constitution?
So when the judiciary is held unaccountable, right? This is a big issue that exists with the judiciary, is that our Republican form of government is that the lawmakers or the politicians are subject to the people. So when you make the judges outside of the control of the people, they can do whatever they want, right? So when you say that I can't hold them accountable for their actions against me, I can't hold them, civilly liable or criminally liable. If I can't do that because they're outside of that, then we don't have a system of government where the politicians or the leaders are subject to the people. We can't have that. We can't have them be outside of the confines of being subject to the people, or being responsible to them, which is what we have today. So then you have, the president that's going to put into place whoever he wants to advance his own political interests. And that person is going to be out of touch. That's not going to be subject to the people of the United States for whatever rulings or decisions they put into place. And if they make decisions that are contrary to the will of the people, the thing is that those people are meant to advance the will of the people, not their own issues, not their own, but the will of the people. They're there to do that. And so if you look at it from a religious perspective, they would be the priests, the ones that would be teaching the religious practices of the people, of the congregation. So if the people themselves have got a desire for, pro-life, right? They want to maintain life. That would be the desire of the people. But then you have the religious scholars or the priests that are saying, we're going to do something different, and teaching them something contrary to their faith. And so, that's what's happening, is that the goodness of the people, or the consistent the actions consistent with the morals, must be driven by the court, by the justices. And so when they're making their own morals or their own customs that are contrary to people, then they're leading the people in the wrong direction. So if you have criminals that lead the country, then the country is going to be led into criminality. And every single one of these judges are all criminals, because every single one of them are not abiding by the Constitution of the United States, which is a crime. It's a crime of perjury, right? And so we have the leadership of our country, every single one of them being criminal, and we now have our country going into criminality. So before we can hold the people accountable for their crimes, we must first get our leadership in compliance with the law. And that means that they must be subject to the people. So,
and this is why FreeMe Podcast is in existence, to try to bring awareness and unity to our communities. We have to stop attacking each other. We have to stop calling the police on each other. And in my opinion, we have to stop fueling this system by sending our children into this corrupt system, thinking that they're going off to be heroes and do heroic things. And we have to stop voting, period. Until we know that our vote counts, until we know that corruption is out of our government, we have to stop fueling it. We have to come together and unite. These are just some of my solutions.
And so the whole class-based system, the whole business issue, that's what we got to get away from, everybody. Government is not a business. Our system is not a business. It was created to be that way because they had slaves and they had property, and property is, of course, an asset. And so we built a system of government that's based upon a business model. And when you have a business model, the government wants to make more business, and the business that they're in is enslaving the people, is incriminating them. So we got to get away from this whole business thought, the riches that we have doesn't come from the things that we have, but rather from the things that we do. And we need to be doing things now. So, you know, when he said that I'm offering what I know for free, I have to. What God gives freely to me, I need to give freely to everyone else. It doesn't come at a cost because it wasn't given to me at a cost. So we all need to be recognizing what empowers us, what we have an advantage in, our knowledge that's unique to our individuality, and we need to be offering that for free to everybody around us, because with knowledge comes power, right?
Exactly.
If I'm able to speak to everybody here and I'm able to pass on to you the knowledge that I have of the Constitution because of the blessings that God gave to me, then that raises everybody up. That benefits me as much as anyone else, and I can't do that at a price because the people that I'm giving it to don't have money.
That's exactly right, partner. And we love you, Tanawa. We love you for what you do, partner. And again, we the people, power to the people, and be honest, tell the truth, stick by what you feel is right. And again, from FreeMe Podcast, the Thomas FreeMe TV and podcast show, I thank you for subscribing and listening and sharing awareness for what it is that I do. As you heard, you know, at the top of this episode, you know, YouTube again canceled my monetization, so I'm being censored, and I need support from the community. Like you have to speak out for FreeMe Podcast, and so that I'm able to bring these episodes from Tanawa and such. So awareness, community unity, power to the people. From Tanawa and I, our next episode will be on Barron versus Baltimore. Tune in. We love you guys. Thank you. Stay blessed, stay healthy, stay proud, stay American. We're out.
God bless everybody. Thank you.